Ladies and gentlemen, we start new season now Institute, and at the same time we will start the international event, festival, the window to the Netherlands. This lecture is the first event in the long 2-month program of this festival, with the support of the General Consulate and Embassy, and also this event is in the framework of bilateral year, Russia and the Netherlands. And also we will start today the long process of our lovely students' competition, St. Petersburg Students Trial Lawyers Competition, amicus curiae. And we will start from the public lecture and discussion with our honorable guest, the judge, the real judge, practicing judge from the Netherlands, Ruta van der Poel. Ruta participated in seminars, training, lectures, programs with Russian lawyers, judges, members of the bar for about 10 years. So he really loved Russia. He's our friend, and he is a friend of justice. I can say so. What is interesting? Looking at the practicing judge and decided he's a friend of justice. It's probably not typical for Russian judges. And when we established this competition, amicus curiae, and ran 2 first competitions, 3 years ago and 2 years ago, we recognized that our lawyers, not only law students, but also our practitioners, need some specific skills and probably specific attitudes to law, which they never learn in our universities, or law schools, academies, or from colleagues. We need to renew, to discuss again, to rethink the goal of the legal profession. In Russia, it's probably topic number 1 for lawyers. To rethink what are the goals, what are the reasons for them to be lawyers, what is the role of law in the society, and how lawyers, judges, lawyers, business lawyers can participate in coming social changes. Everybody knows that the social changes will come soon, and it will be very serious social change. Look at the role of law. 4 years ago, Ruta made a lecture on what is a good judge, a view from Europe. You're welcome. Welcome. And now, after 4 years, we came to another topic. How good lawyers should look like from the point of view of the judge. I want this to hear this lecture, but I also want to participate in a very interesting discussion, your discussion after this lecture. So please put your questions, put your notes, take your notes when Ruth will make a speech. And then I hope we will continue discussion in our specific English, or it doesn't matter what level of English you have. We will achieve enough level of understanding, I believe, in our discussion, thanks to Ruth, who will be our presiding judge in our discussion. And then, in the very end of our meeting, we will announce the new competition, amicus curiae. It will be interesting for students, maybe, Now, I will give you the page.
Thank you.
Yes. Ruta. Wonderful.
Thanks, Madam. You made me blush. Don't spoil me. Let me first. I see a few familiar faces in the first row. I have seen you before. I think I have seen you too. I think. Were you participating in the Right. I have to excuse myself for not speaking Russian, and English is not my native language either. So please don't bother about any mistakes, because I have been so nervous in speaking to you in English. Especially when you speak, you talk about your own profession with all the technicalities. From time to time it becomes very difficult. So please forgive me for that. The title of my speech is The Good Litigator, from the point of view of the judiciary, of a judge in the Netherlands. That is to say, what do judges in the Netherlands expect from good civil commercial trial lawyers? But first of all, let me introduce myself a little bit more. I've been a civil litigator in The Hague in the Netherlands for about 8 years, from the end of the 80s till 1995. Then I switched to the judiciary. I became a judge in the first instance, also in commercial law. Then I became an appellate court judge. Then I switched again after a few years to the first instance to train young judges in their professionalism. And after that I decided to go back again to the appellate court, because that is judicial decision making more at a distance and more reflective. I like to write and I like to analyze and study law. Study the law more than this is possible as a judge in the first instance. Hold on for a moment. Let's sit some chairs. I have just introduced myself, been a lawyer myself, commercial trial law in the Netherlands, in The Hague, with a judge at the first instance in the appellate court, back to the first instance, and now I'm again in the appellate court. If I look at my work, then it comes to my mind that if you try to catch the essence of judicial decision making, it is nothing more but choosing. It is choosing to create some sort of order in society. When parties have a problem, they can solve their problems by negotiating themselves. They can go to a mediator. And as an ultimum remedium, when they then do not succeed in solving their own problem, we have judges to make decisions, to choose. It means that judges do not solve problems. They choose, they decide. They choose either between the position of the claimant or the position of the defendant. They choose between rewarding the claim or rejecting the claim. They choose, as a matter of fact, if you look at it that way, between black and between white. In civil law and in commercial law, no, let me first say this. This has an advantage that it creates some sort of order. As a last instance, there must be a judge who has the last word. But the disadvantage of this is, and I find that during the years, the more and more problematic, is that it leaves no room, hardly any room for grey colors. It's black or white. While in the commercial law business and in civil law, there's so many open norms to fill in by judges. And the judge cannot choose between, let's say, gray and white or gray and black. It has to be black and white. So what judges do usually when the facts are not black and white is trying to convince the parties that it would be better to negotiate by themselves, reach an amicable settlement. But I find that more and more frustrating to have to choose all the time between black and between white. Today I have chosen 4 topics to discuss with you. Whether you like it or not, that's the way it is. That's a choice I made. And the first topic will be what the lawyer's position in the Netherlands is. Is the lawyer to be regarded as an officer of the court? That's what they... There's another guest. Kira, come in. No problem. Good to see you. Please. It's an Anglo-Saxon term, the officer of the court. But it's an interesting question in the Netherlands too, whether lawyers are to be considered as officers of the court, who have a responsibility that stretches beyond the mere client-lawyer relationship. The second topic which I would discuss is the importance of the facts. And the facts, ladies and gentlemen, the facts are the lawyer's domain. They are the territory of the lawyers. I will speak about that extensively. I will discuss with you a case which I have taken from daily life. It happens hundreds of thousands of times, so that will appeal to your imagination. And I will show how judges think while taking steps in analyzing a civil commercial law case. And in the last instance, I will speak with you about do's and don'ts during an advocacy plea. Let me start first with the question whether lawyers in general are to be considered officers of the court. And then I will have to start with the rule of law. The rule of law, as we consider it in Europe, is meant to protect our freedoms and our human dignity by the fact that everyone is bound by the law. Living together presupposes infringements on that freedom by others and by authorities. The rule of law makes sure that only infringements take place that are properly legitimized and that no unbalance exists between the power of the one but the power of the other. Living together requires from all of us a certain amount of tolerance and moderateness, listening to others, taking into account the interest or values of others, and weighing those interests. These are important notions in this respect, and I think that the values of these notions is still of great importance. Let me cut corners. It is against this background of the rule of law that in the Dutch bar, a discussion has developed on the question whether lawyers are to be considered officers of the court, for whom a core value of their profession is what we call public responsibility, that stretches beyond the interest of the lawyer-client relation. It is generally accepted that in the Netherlands, the lawyer is not such an officer. And I mention in this respect that in the international context, no choice in favor or against the role of lawyers as officers of the court has been made either. The basic principles on the role of the lawyer, which has been adopted by the UN Congress in 1990, the lawyer is only called, whatever that exactly may be, an essential agent of the administration of justice. However, coming back to my point, it goes without saying that a rule of law-based society can only exist thanks to the existence of an independent judge and thanks to an independent bar. Each of them responsible for himself, but at the same time both responsible for the quality of the administration of justice. In this context, I would like to quote our former General Dean of the Dutch Bar, the Dutch Bar, Willem Beckers, and some of you have met him. He wrote the following, and I can only underline this very much. The bar has a civilizing effect to the proper administration of justice. Advocates facilitate others, do not enlarge conflict, and take into account third-party interests as far as this is reasonable. They stimulate reasonableness of all persons concerned. They encourage and they support. If I switch now to make a switch to the principles of Dutch civil procedure law, then I have to take into account that as a principle there is an autonomy of the parties. The parties, the lawyers, are autonomous in this respect that they are the ones to decide what kind of a conflict and the frame of the conflict they want to be decided by the court and what not, what questions they want to be decided by the court and what questions not. But this autonomy is limited. The law explicitly obliges the lawyers of both parties to bring forward the relevant facts of the case, and then it's in the law stated, complete, and according to the truth. In practice, this means that the parties may not withhold facts and may not bring forward facts that are not according to the real state of affairs. I will speak about the importance of the facts shortly. Well, this underlines my point that in civil law procedures, lawyers have a responsibility that stretches beyond the interest of the lawyer-client relation. They must bring forward the facts complete and according to the truth. Let's go to the facts and the importance of the facts. You may have heard, you all know Latin? Of course. You will know this saying. Dammi facta, which means give me the facts. Probably some of you may have read Charles Dickens. He wrote a book in the 19th century called Hard Times. And in my mind is one of the sentences in that book, which I would like to quote. He writes, "Now what I want is facts. In this life we want nothing but facts, sir. Nothing but facts. Dammi facta." And the judge says, "Give me the facts, and I'll give you the law. That will be used." Now, the question is, what am I exactly aiming at? In short, it is this. Collecting and establishing the facts is the starting point of each judicial decision-making in commercial civil law. It is clear that the application of the law, whether it's the explicit text of the law or whether it's basic principles which are not written, can take place only when judges have established relevant facts. Therefore, the task of any judge starts with getting a clear view of the facts, the story of the parties, because they form the basis, again, of each proper judicial decision. Now, I'll have an example to give. Very simple case. There is the claimant A, I call him A, and he demands in his writ of summons, or what you call it, statement of demand, statement of claim, he demands from the defendant that he fulfills his obligation to pay the purchase price for stones that A has delivered to B, has sold and delivered to B. Now, the writ of summons a statement of claim, sums up the following bare facts. A and B concluded a purchase agreement for the sale of stones. A has delivered the stones to B. B has not paid the purchase price. These facts are by themselves necessary and relevant, but they're not enough. They do not suffice. The judge needs to know what this case in reality is about. In short, he wants to know, why does B not pay the purchase price? Is it because he has problems paying his debt? Is it because he has found that the quality of the stones is inferior? Or is it for some other unknown reason? Coming back to the lawyers, it is the task of the parties' lawyers to bring up these facts in their court documents, to explain to the judge what the story is all about, supported with all sorts of evidence, of course. It is the judge's task to establish the facts that have taken place in reality. Back to my example which I gave, if B claims that delivered stones are of an inferior quality, the judge wants to find out whether this is true, or whether this is just an escape of B to avoid payment. Now there comes another question. Why is it so important, in my opinion, that a judge aims as much as possible to establish the facts according to the real state of affairs? The reason is this. A fair judicial decision must, at least as much as possible, have its foundation in correctly established facts. I realize that the objective truth will never be reached, but we must strive as much as possible to correctly establish the facts. Truth and justice, in my opinion, they go hand in hand. And I would say that it is as just as unjust to apply the right rule to the wrong fact as to apply the wrong rule to the right fact. It is for this reason that it is a judge's task to strive to collect the right fact for a proper assessment of each case. And it underlines my point that administration of justice is not fiction. And it is exactly for that reason that lawyers, in my own practice, my own experience, they usually do, should not underestimate the importance of the facts. Moreover, they should pay extreme attention to the facts. It is their territory. Backgrounds of an agreement, what is the background? Who are exactly the contracting parties? What exactly is that business about? What went wrong? For what reason? And usually you have to know that the judge is ignorant about these facts. He doesn't know it. He needs you to explain all that to him or to her. So why not inform him properly to enlarge his understanding of the case and its background? From that point on, I would like to shift to put focus on the lawyer's task regarding the composition of the court documents, notably the statement of claim and the statement of defense. I think that it is necessary for any good lawyer to realize by himself how judges think. Because it will help them in their presentation of their case, and it will help them in the composition of the court documents. So it's necessary to know how judges think, and let me give an abstract of what we learn usually to young judges and court clerks who make concept judgments. It starts with this. The first thing is what the judge does is, what is the claim about? What is it exactly? What does the claimant want from the court? What do they want me to do? I come back to that point later on. Second, very important. What is the legal basis of this claim? What does the lawyer say in his court document about this legal basis? And I mean with this, for instance, let's say a breach of contract. And its consequences. Or performance. I want the other party to perform. Please pay me the purchase price. Or compensation of damages. Any claim needs a legal basis. No legal basis, judge won't touch it. Judge only has his authority, can be based on the law. Whether it's the written law, or whether it's the underlying basic notions of good faith, principles of reasonableness and equity, which are also in Article 6 in your Gражданский Codex. So what you have to realize is that this is what the judge searches for. No legal basis, he has no authority to decide. Third, there I come, facts. I need the facts. The facts that could, if they are established by the court, justify the reward of the claim on this legal basis. Then, if I pass that barrier, no, I have to say this. There's two options. The facts do not suffice. They do not support the claim. In theory, that means that the judge doesn't even have to look at the arguments of the defense, but the claim must be rejected. There's no facts, in theory. But if the facts are relevant, and if the facts are they justify the rewarding of the claim, then he turns and he looks at the defendant's position. And there's two options. The judge asks himself, when reading the statement of defense, does the defendant challenge these facts properly? There's two options again. The relevant facts are not challenged by the defense. If they are not challenged properly, then the law prescribes to the judge that he has to establish these facts as fixed. They're not challenged. So they're fixed. The judge establishes these facts as true. But if the defense challenges these facts seriously, then usually it is the claimant who has to come up with evidence or additional evidence. The judge looks at the question whether the claimant has proposed to give any further evidence, if the evidence which has been given already is not enough. But this is basically, of course there's all sorts of details and tricky things, and there's side alleys. I will not discuss that because that would make it too confusing. But basically, this is the scheme with judges who decide in a continental law system reasoning from the law and the facts uses. I think, I'm not sure, you will know that probably better than I do, but that Russian judges probably use the same sort of abstract to look at the case. Now let us forget about, no, not forget about, but have a look at how this works out for the lawyer in his court documents. Very practical. Very practical. I go back to my case, which concerns A and B. And A is an entrepreneur, B is a natural person, and A and B have concluded the purchase agreement. A sold to B 50,000 stones for his garden, against the price of, let's say, 10,000 rubles. And A delivers the stones, so he performs his obligation, but B doesn't pay. So A starts his lawsuit against B, asking the court to order B to pay him the 10,000 rubles. Now let's go and have a look at the statement of claim. What it should, in this simple case, which happens millions of times, what it should look like. Statement of claim. Yeah. First, a claim must be, should be described very precisely. And I would like to ask you if you have any idea why this claim, why it is so important to write the claim, describe the claim in a very precise way. The claim, it means that it's the conclusion of your statement, I want the court to do this and that. So do you have any idea why it is so important to write it very precisely? Does any of you have an idea about it? You understand what I mean? So, why is that so important? That's pretty easy.
Because the judge should understand what do you want the first time.
Yeah, that's one reason. Not only the judge must understand, but the defense.
The other side must know what are the problems from the first side.
Yes.
The second party must be aware of this problem.
Yeah, and they must clearly know what do I have to defend myself exactly against. So both for the judge, who has to reward the claim or to reject the claim, and for the defense, it is of great importance to see what exactly is this case about. What do they want from it? There's another reason, also very important.
If the claim is not precise, there could be many points of view on the situation, and it's right thing to choose the right position, the right point of view on the claim. But if the claim is not precise, there could be many points of view.
Yeah, it's getting confusing.
It's getting complicated, yes.
Yeah. Yes, but there's another very important reason. Yeah, absolutely. It causes so much trouble. But a very practical reason.
Maybe because if it will be not in the right way, it can be easily declaimed.
Say again?
Declined. I mean.
Declined. You reject it. Yeah, that's true. If the judge finds, well, what the hell do they want?
Yeah.
I can make nothing out of this. Then in theory that would mean reject. But there is something very practical. Maybe this is not in Russia so, but
Maybe the price?
Say again?
Maybe the price of the claim, I don't know.
No. No. Think hard. It's you know, if a judge has decided, there's a judgment, and this has to come into legal force, no more appeal. What happens then? Say that the court says, I award this claim. What happens then? Then you have this judgment, in which B is convicted to whatever. What happens then? Well, you have a nice piece of paper. What is the use of all that? You can enforce. You need a bailiff. You have bailiffs in Russia. And they take the judgment in the name of the Russian Federation. I go to B.
And you show you this bailiff?
You come here with this money. I can execute. Execution. Execution of a judgment. That is a final stage. If it doesn't come to an appeal, or in appeal the claim stays the same, and though the judgment stays the same, the appeal is rejected. Then, as a party, your client, he needs this to execute. He needs to go to the bailiff, go to B, and get my money. Sell his house or his car or whatever. That's the ultimate consequence of what judges do. They give you the possibility to enforce their decision. It's a form of violence, which is legitimized by the law. So, what happens if you go to the bailiff with this judgment, and it's blah blah blah, abracadabra, what's in that judgment? Well, what would you say? What would be the consequence? I can make no shot without it, we would say. I mean, the case I gave is a very simple one, and you have very, very complicated claims or reliefs sought. And of course, with this A and B and the purchase price, very simple example, but it can be very complicated. So, what happens then if you have a complicated demand and it's in the judgment, exactly like you as a claimant wrote it down, then you go to the bailiff and the bailiff goes to B. You get problems with the execution. How can I enforce and execute the judgment in which it is not clear what is exactly wanted? What's the result? You can start all over again. And that's what I would like to make clear to you. The importance of writing down very precise. That's lawyer's task. Very precisely. And of course, if it's not clear, a judge can always, during a court session, ask. Maybe you can change your demand in Russia. In the Netherlands, you can, under certain circumstances. But basically, let's not talk about all kinds of details. The basis is that this should be, it should stand like a rock, this claim, to prevent any problems in the execution, during the execution. Okay, then you have to realize in your statement of claim, of course, coming back to that abstract which I gave previously, what is the legal basis of my claim? Mr. Judge, Mrs. Judge, I base myself on the foundation of performance under the law, or breach of contract. You have a wonderful section 3, general part of the law of obligations in your Organized Codex. Obligations, it's in Article 309, must be performed properly in accordance with the terms and conditions of the obligation, blah, 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 blah. You have obligations under the law, you have obligations in contract. And in the case I gave, it's an obligation to perform under the contract. As you see in Article 307, I believe through your your law. So realize yourself, think, what is the legal basis for my claim? Remember, no legal basis, judge only. In our case, which I gave, I think I already said it, but what would be the legal basis? A has performed by his obligation to deliver these stones, but B, he hasn't paid purchase price. So what would be the legal basis for a claim that B must pay his 10,000 rubles? What's the legal basis you mentioned in your statement?
Some sort of contract they signed.
There could be a signed contract and between an entrepreneur and a natural person, but that is not the answer exactly I'm looking for. It is one of the relevant facts. But what would be the legal basis for having the 10,000 rubles? You must find something in the law.
Right.
The legal basis is an article in the Гражданский Codex that the person who buys something must pay for it, and according to the contract between them,
Yeah.
and pay in rubles.
Yeah, let me have a look. It is in Article 307. By virtue of an obligation, one person, the debtor, is required to perform in favor of blah 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 blah. Obligations originate under a contract. Obligations must be performed properly. So I think, if I would translate it to Dutch law, which is in that respect not so much different from your law, it would be performance. And what B does is non-performance. But I want him to perform. He has to pay. Performance. Performance of an obligation under the contract which A and B have concluded. Now, then we come to the facts. Can you give the facts which are at least relevant and necessary? I think we already discussed it, but no. What would you mention as facts in that case I gave on the side of the claimant?
The first fact is that A has delivered all the stones to B and has performed his obligation properly.
Yeah.
So,
Well, why not start? Let's be very precise. Certainly, why this is a very
first
They have concluded a contract.
yes.
They have a contract. A contract. Then we have. I fulfilled my obligation
Yes.
under the contract to deliver the stones. So that means I deliver the stones. Another relevant fact, which you should mention in your.
B hasn't paid.
Yeah. He has not. In the juridical way, it would be.
He
Of course.
has not performed
He has not performed his
obligation.
contractual obligation. B has not paid. And like I said, it would be good if you know suppose you know already what the defense is, what the arguments of B are, not to perform. Let's say the inferior quality of the stones. It would be good to go in that argument and explain to the judge that this is crap. And for this and this reason it's nonsense. And I have for instance, an expert opinion or whatever, to show that this is nonsense, that the stones are of good quality, yet he could not have expected anything else than the stones you have delivered. So this is basically, I think, what should be in their statement of claim. Let's go through the defendant part, which is can be more complicated. Statement of defense. Now, let us assume, makes it a little bit less complicated, that B acknowledges that they concluded a contract, that he acknowledges that A has fulfilled his obligation under the contract to deliver the stones, and that he has not paid, he has not performed his obligation to pay purchase price. But that he argues, I should not have expected this quality of stones. The quality of the stones are inferior. What I first of all would like to ask you, as a lawyer for the defense, before you start writing, try to realize what goal you would like to reach. What is your goal by defending the position of your client? Going back to this case, what could be, most probably, the goal of the defense? What would you like to reach? What would your goal be as a lawyer for the defense in this case? So that defense is B, the one who has not paid his purchase price because of his so-called inferior stones.
One of the goals can be the achievement of the required quality of stones from A.
Can you repeat that?
B wants to achieve the required quality of stones from A, and that's why he tells
He wants, yeah.
the judge that he won't pay before the quality of stones
Yeah.
won't be in this way as B wants to have.
Think a little bit more analytical. You're going in the right direction. We'll talk about that. I saw somebody pointing.
I was about to say the same thing as you.
Yeah. Let's put it differently. If I be the lawyer for B, what do I want the court most probably to decide?
Satisfy the claim?
Oh, no.
The other way around. Reject the claim. I want the court to deny A his claim.
I mean, satisfy our claim.
Yeah.
Counterclaim.
Yeah, we'll come to speak about that. But let's keep it a little bit simple. It means that you have to think, what is my strategy? What is my point? Where is it going? Don't just write anything and think analytical and start with thinking, what is the aim of my client? Most probably, the court must reject his claim. Another question in this respect. How would you, and let me write this down. B's defense is, the stones are shit. The quality is too bad. I should not have expected this out of the contract. How would you qualify juridically his defense? Looking from the point of view of the law. How would you qualify? You see, this is again, I have to find a legal basis in the law. It needs a foundation in the law. how do you juridically, legally, qualify this?
According to Гражданский кодекс,
No.
the quality of the purchase must be the same as it was written in the contract. So
Yeah, but where is that in the codex?
I don't know the number of the article, but it is near the article 307 in this
Does anybody know that by heart? How would you qualify that? It's pretty easy. What he says, what B says is, you point out that correctly. You did not fulfill your obligation under the contract. So what else could that be than a breach of contract? At least, in my opinion. It's a breach of contract, which is also in your law. Without going too much into details, liability for breach of obligations, etc. It's a breach of contract. You did not fulfill your obligation under the contract. Breach of contract. Is it clear to all of you that you have somehow to leaf through this booklet and try to find a legal basis for what you are arguing? I mean, this is also, again, a very simple case and can be much more complicated. But always as a lawyer, I think, what kind of argument is this under the law? Is it a tort, a lawful action, breach of contract? So, if you would qualify this as a breach of contract by A, then there arises another question. Think hard. If you're going back to your goal, if your goal as a lawyer is to convince the court, the judge, that the claim must be rejected, the claimant will pay 10,000 rubles by B. And B's defense is, it's a breach of contract. You understand why I'm aiming at? Does that release, I mistake. Does this defense, breach of contract, does that release B from his contractual obligation to pay the purchase price? In other words, how effective is this defense, this argument, to get the court to reject the claim? Does it release B's obligation to pay the purchase price? Suppose the judge establishes that there's a breach of contract. Let's suppose that. Does it relieve B from his contractual obligation? Yes or no?
Yes.
No. First, yes. Who said yes? Please, can you
I think that B has several ways to resolve this problem. He can go and try to terminate the contract, or just not.
Yeah.
Just.
You got the right point, but we'll go into this. But this is not an answer to the question. First, the question is: does this relieve B of his obligation to pay the purchase price? I come to what you're saying in a minute. And now, anybody else said no?
Well, I think that he is not. It doesn't release him to put. Doesn't release him to pay his obligation contract because anyway he has to pay that amount of money, and I don't know how to explain it, but it's kind of hard to explain it now because I don't know why But really, if you think, he got his stones for his yard anyway, and he has to pay for that. But then he can state a claim, like a statement that he didn't get what he wanted to, and then he can apply for a court and he can get whatever he wants to. So that's one.
But the answer is, I don't hear an answer to the question. Suppose A committed a breach of contract by delivering an inferior quality of stones to B. Then you have to ask yourself as a lawyer, we'll come to your point in a minute, because that's important what you said. Does it relieve B from his obligation to pay the purchase price? I don't think so. Not just that argument. And I'll also give you the reason why not. And the reason is this. If this is true, the consequence might be compensation, damages, or termination of the contract. Could be asked by being a counterclaim. We can't speak about that. But on its own, this argument does not touch the validity of the contract by which B has to pay. If this is true, the contract is still there, and he has to pay. So, if you as a defense lawyer think that your goal is the claimant be rejected, and you stick to this argument without a counterclaim, you get nowhere. Because it does not touch the validity of the contract. So the question arises as a lawyer, you must think to yourself, this does not help. This is from practice, this happens. It happens hundreds of times. Then I have to ask the lawyer, but it doesn't relieve your client from his obligation to pay, so what next? Then you have to ask yourself as a lawyer, then come to your point. What could be the consequences? What could I do to reach this goal? What remedies exactly do I have to release my client of his obligation to pay? So there's certain possibilities, also in the Russian law. You mentioned what? Somebody said the counterclaim. I think so too. And you said termination of contract. There you go. You start a counterclaim and you say to the judge, this is a breach of contract, which might give rise to my counterclaim, and I want you to terminate the contract. And if I took a quick look in your law book, this is in chapter 29, ground for the amendment and termination of contract. So you could ask, remedies. You know, this is quite important. If you don't do that, there you go. So, termination. Termination of the contract. Yes, that's one remedy. There could be others too.
Compensation.
Who said that? Compensation of damages. Who said compensation? Please. You? Compensation. That's correct. Compensation, damages. Yeah. Suppose Well, what happens then, technically, is that in your counterclaim you ask the damages to the same amount as the purchase price. And then those are compensated against each other. That would lead to the conclusion that in the claim you'll have to pay. The court would say you have to pay the 10,000 rubles. But at the same time, in the counterclaim, the damages are rewarded to 10,000. You say, well, that's it. So, as a matter of fact, it leads to not a rejection of the claim, I think, but to compensation.
Now there's another, I saw in your law book, another possibility.
Which would not probably lead to the whole claim being rejected, but you could ask the court of, at least theoretically, to amend the contract and to say, oh, have a look at the, if we look at the quality of these stones, which are not of the quality that B must have expected, the value of these stones is not 10,000 rubles but 5,000 rubles. So the claim above 5,000 must be rejected by the court. So you have a possibility of amendment of the contract. You have the same in Dutch law. Amendment. There's another possibility which could be one of your goals. I think you mentioned this earlier. You could, for instance, ask the court to order A to perform. I want prop stones. But I think that at the same time, that doesn't lead to the rejection of the claim. But what you could do is that you ask the court, but I do not know how exactly that works in Russia, that your own obligation to pay under the contract is suspended for the time being until the moment that proper stones are being delivered to you. So that means performance. Proper stones. And a suspension of my obligation to pay purchase price until A has performed properly under the contract. So, as a defense lawyer, you have to realize very well what steps to take, what goal, what is the legal basis, what are the remedies to reach, to a great extent, the goal for my client. And all this has to be written down in your defense statement. Okay. I would like to start a completely different subject, and that is actually my last point, and that concerns the advocate's plea, the do's and don'ts of advocate's plea when approaching the court. But maybe it's a good idea to have just a 5 minutes break, have a cup of tea, if I can, agrees. So is our director. Well, is this clear? The systematic approach of how judges think and the importance that lawyers realize themselves how judges think in the composition of that court. Is that clear to me? Please, afterwards you can ask any sort of question. But you know, it's a very technical and analytical way of thinking. Can we have a little break? 5 minutes? And then we'll switch to another point, the advocate's plea. Do it. Thank you.
Okay, I will start the last part of some of the things I would like to say, but not the least important part, because one of the most difficult things I think for lawyers is to convince the judges of the correctness of your view. And during the years, I have seen so many lawyers doing things which I thought, I think I could do better. I don't know whether that's in reality the case, but sometimes I think for myself I should switch again to the lawyer's business and try again myself. I have 10 do's and don'ts written down during the years, which I would like to share with you. First of all, let's have a look at the definition of what an advocate's plea is. And I don't know whether you have advocate's pleas in Russia. You have, of course, oral hearings before the judges, but maybe that's not comparable always with an advocate's plea which we have in our country. My definition of the advocate's plea would be that it is it's a court hearing in which, as a rule, it is the parties' lawyers who take turns in explaining their client's view to the court in front of the court. And first of all, I think it is important that you realize as a lawyer, before you start asking for an advocate's plea, at least that is how it works in my country, what exactly is the reason that I ask for an advocate's plea in this particular case? Is it because I want to inform the judge about recent developments concerning this case? It could be on the facts, but it could also be that there's recent developments in the jurisprudence of the higher courts, or the court in Strasbourg, which plays an important role in this particular case. Very important is that if there are new facts which play an important role in this case, that you would like to inform the judge about. It is my personal experience that a hearing, an advocate's plea, is most of all beneficial to a clarification of the facts of the case. As I said earlier, I think I started even with that. It is the facts who are the lawyer's territory. So if there are new facts which shed a different light on the case, or which are in other ways important, then you should inform the case about the judge about these new facts. They might give the judge, is my personal appearance, much room for asking questions. And the advocate's plea has as advantage that the parties' lawyers can react immediately on what's going on and what's being said. And apart from that, it is also my personal experience that a judge is in general quite interested in seeing the parties behind all the paperwork and talking to them personally. It usually also adds a different flavor than merely judging on the basis of what I call the paper file. So that is the first aspect. So that means try to reason and think about yourself as a lawyer. Why do I want this advocate's plea exactly? That's the first. The second is there is an ever repeating irritation of judges, and that is this. You have to realize as lawyers that the judge has read the file, the dossier, very shortly before the advocate's plea, and has prepared, in most of the cases, also particular questions to both the parties. Therefore, I always say to lawyers in the Netherlands, please, do not repeat everything that's already in the file. Don't. It's annoying to be forced to listen to arguments that are already there, which I've read already. And it is ineffective because you lose completely the court's attention. And that is, I think, as lawyers, the last thing that you would want. The third aspect, also quite important, try to limit yourself. It follows from what I said before, of course. Try to limit yourself to new facts, or undisclosed facts, new legal developments which are important. And I think that if you can do that, and that takes experience, I realize that. As a starting lawyer, you don't want to lose anything. You're afraid that I'm not talking about certain subjects, you will lose something. But once you get practice over the years, you have practice over the years, you're getting professional, then you see that a good lawyer can limit himself and says to the court, for instance, I took over this case from lawyer so-and-so, and the legal grounds which he raised, which are 4 in total, I dropped 3 of them. There's only one ground that is of importance. I want to plead on that ground. I want to speak about you. I have new facts, there's new jurisprudence, etc., etc. This is what this case is all about. Then you have the judge's attention. Be sure of that. The fourth point is, and that goes without saying, a court of law is not a university or a school. Don't teach the judge. Don't do that. That's patronizing, it's annoying, and it's arrogant, of course, that I'm saying that. But the judge usually knows the law. Come up with facts, new facts. I see somebody nodding. That this is not true, but speaking about my own experience in Europe, that's not the law. I would like to hear how this is assessed in Russia, but we'll hear that afterwards. My fifth point is that when you approach the court, try to avoid the use of exaggerated language, big so-called big words. Bringing forward your arguments in all modesty is so much more effective than to carry your point in a loud voice. I think that the strength of a good lawyer rests mostly in the way in which he's able to present the facts in a quiet and convincing manner, and places these facts in a, for his client, favorable light, which is also quite difficult from time to time, I think. But that characterizes a good lawyer. Very convinced of himself, puts the facts exactly in a, for his client, favorable light. Being very correctly, very businesslike, very quiet, make his point. Sixth, I think that fluency as a lawyer, that helps, but what is more important is, it follows from what I said before, is modest, quiet presentation. Good preparation, good knowledge of the file, good knowledge of the case which is at stake, and a good knowledge of relevant, if relevant literature, jurisprudence, or what you have in Russia is guiding resolutions by the plenuma of the courts. I think that is important in Russia. The seventh point is, and that also involves a lot of experience. I realize that you're playing a role as a lawyer, and being a young lawyer without much experience, it works on your nerves. But once you become experienced in your job, you'll find yourself most convincingly if you can be yourself. It works the same way in my job. I was absolutely nervous as a young judge. How would they look at me? And now I just don't care. I am myself, and that helps. That convinces you being yourself as most as possible. The eighth point is, it might help, especially when you're beginning a young lawyer, is to prepare a written note. It helps because preparing so forces you to prepare your speech properly. And if you are convinced of the fact that you have prepared a good speech with convincing arguments and a clear phrasing, I don't think that much can go wrong. That certainty will give you confidence, and if you prepare a note, how difficult that is, you see when I'm speaking from the paper, try not to be too much attached to the written text all the time. The ninth point is, in addition to what I said as the 8th point, try to learn the text, part of the text, by heart. There's absolutely boring to have to listen to a lawyer who goes like this. He reads his text, 24 pages, you lose all your attention of the court. I mean, it's so terribly ineffective. You have to realize yourself that. And then the 10th point is, you'll have to realize also, well, you come across that if you practice, that always unexpected events happen. Let's say that the other party's lawyer suddenly brings up new evidence, new facts are being presented by the other party, the judge asks nasty questions, your client gives the wrong answers, etc. The English have a nice expression for that, and that is, stay as cool as a cucumber. Just think, don't panic. And when you do not know the answer, nobody will blame you for that. Just ask the court, can I have a minute? I would like to, this is something new I hear. I would like to discuss that with my client. Can I have a break, 5-minute break? That's how it works in the Netherlands. So I'd like to hear how your experience in that respect is in Russia. It will give you the time to assess the situation for a moment and think and discuss it with your client. And then the last thing is, apart from all what I said, any good lawyer knows that in the real life of a civil lawsuit there's always another side of the medal. The lawyer will always be prepared for the unexpected to happen. He thinks ahead and he knows that there's another side of the medal. I will never forget my professor of law in Leiden, who started his lectures in my first year, and he said, in civil law it ain't necessarily so. There's always a different view possible. And as a good lawyer you realize yourself this different view, and you know how to react on that when the other party comes up with that. It ain't necessarily so. That's the interesting thing about civil law. Thank you very much for your attention, and I hope that we can have some sort of discussion. I'd like to hear your view on some topics which are used. So, thanks for your attention.
And now we have time for questions,
Oh yes,
answers,
please.
comments,
Views from Russia.
problems.
Somebody was nodding no in the. Is there your?
Free,
I would like to
free
hear-
microphone. Everybody can ask any question if you have.
Any questions, any remarks, any experiences from Russian courts? I would like to hear. One of the things I said is, come up with the facts. The judge knows the law. But this is different in Russia. Any questions? Did you get what I told you? Did it reach you? Did you understand? And what part of all I said was to you the most, appealed most to your imagination? Was it most practical for you? Was it the analyzing this case, or was it what I said about the advocate's plea, or what did you like most of all? What was most, which you can use in your own practice?
Your advices are very helpful, and thank you for that.
May I ask a question?
Yeah, definitely.
So the question is about what do you think about pussy rights? What's your opinion? They got 2 years of prison, and do you think it's a good punishment or it's?
That's something unexpected. I did not prepare for that.
Just be yourself.
So what's your opinion?
I could not believe my ears. These young people who trespass the law, they should be fined, let's say, with 1,000 rubles or 100 rubles. But they keep them in custody for months, and now they're sentenced for this offense for 3 years. I couldn't believe my ears.
So you think it's?
This is not justice.
It's too much for them.
This is. Now I'm being very much myself. This is the discrepancy between their violation of some law in Russia, that they did, and the final sentence of the judge is too big.
Exactly.
I think you should not go into a church and shout this kind of thing the way they did. You would be fined probably for disturbing church service in the Netherlands too, but you get fined. But 3 years prison, I couldn't believe my ears. It's just, you cannot accept that, at least. And what's your opinion?
Well, I think it's too much for them. If I was a judge, I would give like sentence, not a sentence, not imprisonment, but they have to pay the money, like the money punishment.
Small fine. Don't do it again.
Yeah, they should be fined for like, I don't know, 3 million rubles or whatever, like the big amount of money.
I don't think Russia has oversaw the consequences of this case. The whole world is Moscow court. The whole world knows about Pussy Riot case. They didn't expect that to happen.
Exactly. They didn't even think that they would be stars.
Miscalculation.
Like stars of the internet.
Yeah. But I feel sorry for these young ladies. Imagine 3 years for this. Well,
2 years.
Just
2 years.
2 years. Just
Well, even 2 years.
They chose
2 years.
Андрей виноват в трехкомнатной
They're mothers. They're all mothers, right?
Раз в месяц можно.
Yeah.
They got a good education, by the way. I don't know what they do. Why did they do that? Just so you understand.
Anything about private or civil or commercial law? I hope that it was clear to you, that I made clear to you how important it is to analyze properly and to realize yourself how do judges think, how do they attack the case. And I also hope that I made clear to you that my job requires choosing. And that it is difficult to sometimes it's not so difficult to choose, but to realize yourself that it's not so black and white, that there's gray colors in it. But nevertheless, you have to choose in a reasoned way, of course. But nevertheless, and this is the more so when we speak about the judge's task to fill in so-called open norms. We have quite a few open norms in our law, let me give an example. When did somebody commit a tort, what they call in English tort, unlawful action? When exactly is there a breach of contract? Or maybe that's even a more clear example. When is somebody's behavior in contradiction or violating even the basic principles of good faith or reasonableness and ethics? You have, as a judge, to fill in these norms. And some would say that this gives a judge tremendous discretionary power. On the other hand, there's people who would say it leads to judicial arbitrariness.
which to a certain extent is absolutely true. That is the negative side of a legal time. But nevertheless, also in your law books, there's open norms to be filled in by judges. Also these reasonableness and equity, which are written down in Article 6, which I mentioned, these basic fundaments of the principle of civil law. How do you deal with that? Any questions?
As a judge, how should the lawyer protect his client if he knows that his client really broke the law or something like that he is really guilty?
But then you are probably speaking about criminal law.
Criminal as well,
Ye-
but not so on the criminal. Just he knows that his client broke the law, or maybe broke the contract or something.
Yeah, that he breached the contract. But nevertheless, the lawyer should try to make the best out of it and put the facts. There I come again with the facts. It is absolutely important for a lawyer to place the facts in a convincing way, in the way which is the most favorable for his client. That is the strength of a good lawyer in civil law, because it ain't necessarily so always. Of course, you have cases in which it is black and white, but usually that is not so. And that is also the reason why, as a defense lawyer, you have, and also as a lawyer for the claimant, you have to give the judge all the facts of the case, which I also mean the circumstances, the concrete circumstances. For instance, what kind of business is your client in? How long have they been having business relations together? What exactly in their relation went wrong? How did that come? Etc., etc. You as a lawyer have to at least to assess these circumstances and bring them before the judge. At criminal law, I do not have much knowledge, but in private law, civil law, and commercial law, it's hardly ever black and white.
And then we believe that you have visited Russian courts, or courts of St. Petersburg. What do you think about them, about our courts level, about our judges?
Well, it's very difficult to generalize. I've seen a few court sessions in criminal law. I was surprised to see that those who are in custody are kept in a sort of cage in the courtroom. That is something which is not seen in the Netherlands. But also visit a first instance arbitrage suit, which was, to my surprise, there was a judge who was very interested in asking questions to the clients and the lawyers. And he was very communicative, which is very much to my liking. But I realized at the same time that there's a huge case load which the judges in Russia have. I was also surprised to see that in most cases, judges they pronounce a judgment pretty short after the court session. We don't do that. That's different. We have 6 weeks to write a judgment in the first instance and in appeal. Only in very pressing circumstances it can be done in a shorter time. So I realized that we have much more time. Our caseload is less. We have much more time to put a lot of quality and reflective thinking in it. But I'm not condemning it if you realize that so enormous caseload which you have. It was a very nice thing to see if when I was in the court I saw so many lawyers and clients. It seems to me that people seem to have a certain trust in the judiciary, in the judges. otherwise they would not go to court. I might be wrong, but what is your experience? Any lawyer who's present here?
Students.
Yeah, you are all students, but there is some lawyers. Maybe you can share some of your experience with Russian courts in relating to the things I've been speaking about.
In general?
Say again?
In general? About our
Yes,
experience
please.
in general?
Whatever you want to say.
In any court? Not lecture.
As to me, I think that Russian judges are very closed. It's impossible to understand what they think, and you have to say everything. So, in your example, you have a text of 10 pages, and you don't know what to say to a judge, what is his position or her position. So you have to read all these 10 pages, so as to say you will have the thirds outside, the thirds on staircase. That's why you have to say everything to a judge, and unfortunately he has to listen everything. That's why the main problem of Russian judges is, as I think, that they are very closed.
Does a Russian judge in a commercial and civil law case ever say to the parties, would you like to hear something of my professional view in this case?
Yes.
Let me give you some look in what's going on in my head, and then you can reflect on that. Maybe I'm wrong, and then you can correct me.
Can you explain in more details how it works in the Netherlands?
That's how it works in the first instance. What a judge does usually is he reads the file, then the lawyers come, their clients, and the judge says, well, I have read this file. If I understood well, let me give a concise, what's the word for that? A summary. Let me give a summary of what I read and what the problem is. And if I'm wrong in that, if I understood wrong, you'll have to explain me. Please tell me. I want to have it correctly. Is this the point which keeps you guys divided? And then, if that has been said, then I say, I have questions I would like to discuss with you. If I'm well, then the problem between you is this. Let's discuss it, etc., etc. That's how it works. It is different, of course, in the appeal system, because then you've had already the first instance, and there's a judgment, and there's qualified lawyers who aim their arguments on the judgment of the first instance. It's more distance-like. It's more at a distance. But in the first instance, judges are so active. If they have not enough facts, they say, well, I don't understand, Mr. Judge and Judge, Mr. Lawyer or Mrs. Lawyer. I don't understand. There seems to be gaps there. Can you explain? And he also discusses with the client, and he tries to use the arguments which he hears to use an amicable settlement whenever possible. Just because, in most cases, it's not black and white. And then he says to the parties, well, your strong side of the case is this, and this is your weak part, and in your case, in your situation, that is your strong part, but your weak case is this. Could it be something to try to reach an amicable settlement together? Then I say to the lawyer, so please, the court session is adjourned, and try to reach an amicable settlement. But judges, as a rule, in the first instance, are very active. They try really to grasp what is at stake here. What is the question? What keeps those people divided? It's a sort of, you have a discussion from time to time on the basis of these questions.
So there is no discussion in Russian judge as usual, in a Russian court as usual. So on my last case, I had to say to a judge, what is the place for discussion?
Yeah. Good. And how did they react?
The reaction was without any humor.
Because you have a point there. It is a place to have a debate on facts and maybe also on the rules. But in the first instance, it's most about the facts. What are the facts, the correct facts to be established? Parties have different opinions about. No, it didn't go like that. Yes, it did go like that.
So it's very difficult to be a lawyer in Russia.
It needs tough lawyers
Yeah.
who stand up like you do and say, this is the place to debate. Please, I want you to listen.
But the judge didn't catch it.
Yeah. Okay, thanks for sharing your experience. Sure.
So we know that you have a lot of friends, judges, I think, judges in Russia and in Netherlands, and I want to know, have you ever noticed some unprofessional qualities in your colleagues, and what qualities they were, mistaken qualities? Is my first question, and my second question, and how do you discuss this problem between or among all the judges? And my third question is it impossible to have jokes among judges or among judge and his clients?
You mean what kind of jokes?
What kind of jokes?
Judges are human beings.
Not official language, not official, not so.
You mean among themselves?
Yes.
Not in the courtroom, but afterwards.
No, in courtroom.
Yeah. You have to be, to start with that last point, you have to be very, very careful. It might help from time to time to try to raise the tension, to make let's say, a frivolous remark. But making jokes as judges, but it's helpful to be relaxed and make from time to time. It depends on the people who you have in front of you and the sort of case. When it's something very serious, I don't think I would make jokes or make frivolous remarks. But from time to time that may help. And then you see people start also smiling at least, and then the atmosphere gets sometimes a little better. Your first question was...
Have you ever noticed some unprofessional qualities in your colleagues?
Yes, and that concerns two aspects, and that is in writing of judgment, the analysis of a case, and it concerns the communicative aspect during a court hearing, and especially in the appeal instance. We are with a three-judge panel, and one of us takes turns in presiding, and then you can see that one judge is not exactly like the other. Everybody has his own peculiarities. But what we usually do is afterwards assess the way the presiding judge acted. But I must admit that there is a certain, I'm trying to find the correct word for that, distance-like behavior. I would not say to a colleague with whom I'm working day by day, you behave like an absolute ass. How could you do? No, I would use different words to explain him that maybe a different approach would have been more effective. Something like that. But yes, we discuss, and same thing with the writing. In appeal, It works like this. Usually the presiding judge writes the concept. We are going to chambers afterwards. We discuss the case, the facts and the legal aspect. And of course what the outcome should be, what the judgment will be. And then the presiding judge will write the concept. And then after he has written the concept, it circulates among the others. Sometimes one of them in parts agrees, it disagrees, and then we have another discussion on certain part. Because when you start writing a judgment, then there comes the real details, as you can imagine. And that is different from discussing a case in a large extent in chambers. And when you start writing, then the real details appear. And sometimes we have different opinions about that. But we always come to a common conclusion.
It's clear, thank you.
Thank you. Excuse me, do you think that judges have kind of positive abundance of their background? And
what do you mean with they have
positive abundance?
Independence.
Because of the positive dependence, it means they depend on their background, on their gender, race, or something else, education and something else, and does influence their decisions. Is that true?
Yeah, that's a sociological question.
Yes.
I think.
Sure. But it's very practical.
Yes, it might be. But somebody's background or gender might, and let me try to put that in a very subtle way, in certain delicate cases, I can imagine, especially in criminal law cases, it would not be good to have a three-judge court which exists only of women when it concerns somebody who's been suspected of a rape. Or sexual abuse, or it might be good in some cases to have a more balanced court with men and women. And of course, I cannot deny that your convictions concerning that what's going on in society and problems and cases which are being put before you, you are being influenced by who you are, and what your background is. It does not occur in my view so many times, but I realize that in some cases it does play a role from time to time. Yes, I cannot deny that. Yes, your convictions, your view on what's going on in society. Yeah. For instance, in labor law cases, you have judges who have taken a firm stand against employers. They have been in their former life lawyers who actively defended the interest of workers. Yeah. That is, but you have a good judge always realizes by himself that he has these that he's looking at this kind of problem with this particular background. He should realize himself that.
But is it possible to be a good judge without their dependence, without their background?
I didn't catch it. Sorry. Can you?
Is it possible to be a good judge without the personal background?
You think you should leave your background at home? It cannot be.
Up to you.
How can that be? I'm raised in a certain environment with certain parents, with a certain background, and I have moral convictions, which I developed myself and in which I was raised. Of course. Can't deny it. That plays a role. Yeah. Absolutely. Sure.
How do you think why it is so popular among rich and well-known Russians to solve their problems in English courts nowadays? Maybe you heard about it.
Why it is, let me repeat. Why it is important for...
Not important, but it's so popular nowadays among.
You think that they can, let's say, settle something?
No, I mean,
Can you try to be more explicit?
have you heard about, for example, the case Berezovsky against Abramovich?
No, I don't know. Sorry. Can you explain?
Queen's Court in London.
Oh, okay. Those two guys who are... Yeah, I think that it is my birth. They are two tremendously mean, filthy, rich assholes. I'm sorry to say so. To use the courts in London to fight their own personal animosities and conflict. I have no sympathy with these guys whatsoever.
But it's a great bonus for British lawyers.
Yeah, they earn a lot.
The income for the last month is
Yeah.
In our country, we have a great problem in relationship between executive bodies and judges. When judge have to decide some case, maybe in your experience, do you have some problem, some pressure from the executive body?
No.
No.
No, I do many cases in which governmental agencies are acting as parties. The state, municipal government, the province. No, never. No, I never. I cannot say, I've been doing this work since 1996. And I cannot but say that I have always been being able to professionalize myself and to administer justice with my colleagues in all openness with each other, in independency, absolutely. No, no. Unfortunately. I don't know of such a thing.
You told us that all judges or jurists should learn their speech by heart.
That's right.
That's right. So, how to remember everything in your speech?
Yeah, that is very difficult, I think. But maybe you should start by not writing so many pages and try to limit yourself. What you can do also is try to summarize in the text some remarks which if you see them, that's this point, then you can then you know this is about, then it comes back to your mind and you can easily follow the structure of the text without reading everything. But I realize that's hard, that's difficult. Yeah. But in the beginning, I think that would be a good thing to do, as much as possible. Not like this.
But sometimes you can see there, yeah?
Say again?
But sometimes you can see there.
Of course, and you can pause and stop from time to time, take a quick look at your paper, and then proceed. Yeah. Don't stand there as a lawyer, having learned that by heart, like military, and fix the judge. No, it's also a way of communicating, of course. Stop from time to time, take a look. Okay, next subject.
Sorry for common questions, but one more. What is your opinion about about death penalty in some countries. Do you think it's moral or immoral?
We have abolished the death penalty in all European countries as far as I know. And personally, I'm very much against it. One of the reasons to be against it is that once you, if you make a mistake, it can never be made good again.
But if you're sure that a person is, for example, terrorist, what should be?
But the second point is that you take away every possibility of him to redeem. And better his life. And in the third place, I think it's terribly arrogant to think that the state might take somebody else's life.
Thank you.
Could you say how much is your pie packet in the month?
Can you repeat that in?
Could you say how much is your pie packet the salary in the month?
I refrain from answering that question. No, our salary is good.
It's good, yes.
Yeah. It's, if you're a commercial lawyer, you can earn a lot more money. If you're a good commercial lawyer, you can earn a lot more money. But I love my work so much. I wouldn't change.
Thank you.
Maybe when he was a boy, maybe a child. I did want to be a judge.
No, not at all.
No.
I have a late vocation.
No, you was born.
No. For a long time I haven't been knowing what to do, so I travel around the world.
I wonder, what do you think about euthanasia?
Oh,
That's euthanasia. That's always been a very delicate subject. And the Dutch legislature, like in England at present, didn't want to make any law to regulate euthanasia. So doctors who committed euthanasia were being prosecuted for that. So the judges had to decide. And what during the years happened was the judges acted as deputy legislators. They set somehow certain rules which in a later stage the legislature in the Netherlands took over. And that is exactly what the British judges, highest court, did probably, as I understood, did not want to do with that case, which happened recently in the UK. But yeah, it's the judges who acted as deputy legislators by setting the rules and marking the boundaries in which it is possible to commit euthanasia without being prosecuted for murder as a doctor. And I think that the legislature deliberately left that to the judiciary because they just didn't dare to do it. But they took over. They said, the Supreme Court said this is this rule. Okay, we'll make this the law. It's a very delicate process, which has taken, I think, 20 years or something. That an answer to your question?
in Russia there is a problem that many judges have so much amount of cases that they have not enough time to hear the cases with necessary attention. And there is a problem of quality of decisions in this case. And do you have any such problem? And if yes, how do you solve that problem?
Well, the caseload we have in the Netherlands is also quite big, but I don't think it's comparable with the Russian situation. No, this is uncomparable. When I worked as judge in the first instance, and I work 5 days, and then I have 1 day in which I did court sessions in normal cases, and I had 1 afternoon in which I acted as a judge who did summary proceedings. And on that particular day in which I hear cases, I have at a maximum 3 or 4 cases, which is incomparable with the Russian situation. So I have respect in that respect for judges in Russia. This arbitrage court judge session whom I visited, he told me that he had in one day 22 cases.
70 cases.
70?
Yeah.
Easy. I don't think I would have liked to be in this place. 70 cases. Oh, there's no time for reflection.
And not only the 70 cases, but at the same time,
Yeah.
all cases, maybe 30 cases in the same time.
How can you get hold of the facts? How can you,
This is the situation and the situation.
I would be very interested to see what judgments, how judgments are.
But it's only on the document, not on the court side.
But what does the reasoning of judges look like in civil cases?
I mean, in the list, not in the court exactly, but if you look on the list before court, there can be cases in the same time. But not in practice.
Not in practice.
Nonsense.